the door just slammed shut. And if you are an employer who was planning to bring in seasonal workers for the summer of 2026, or if you are a worker whose entire year was built around an H-2B visa, what just happened in Washington affects you directly, right now, today. USCIS has officially announced that the H-2B cap for the second half of fiscal year 2026 has been reached. Petitions are being rejected, applications are being returned, and for thousands of businesses and workers across America, plans that took months to build are now in serious jeopardy. Welcome to Immigration Path USA, the channel that gives you the clear, accurate, and actionable immigration information you need without the noise, without the speculation, and without the panic. I am really glad you found this video today because this update is time sensitive and the consequences of not understanding it are significant. Before we go any further, here's something I say in every single video and mean every single time. I am not an attorney. Nothing in this video constitutes legal advice. Everything you are about to hear is for educational and news purposes only, based on publicly available USCIS announcements and federal policy guidance. Your situation is unique. Please consult with a licensed immigration attorney before making any decisions about your specific case. Now, let's break this down completely. Let's start at the foundation because a lot of people watching this video have heard the term H-2B but do not fully understand what it covers or why the cap matters so much. The H-2B visa program allows U.S. employers to bring foreign nationals to the United States to fill temporary, non-agricultural jobs when there are not enough American workers available to do that work. We are talking about landscaping crews, hospitality and resort staff, seafood processing workers, carnival and amusement park workers, construction laborers, housekeeping staff at hotels, and dozens of other industries that run on seasonal demand. These are not abstract categories. These are the workers who keep American summer tourism functioning, who staff the ski resorts in winter, who harvest shellfish on the Gulf Coast, and who maintain golf courses and parks across the country. Congress set a statutory cap on this program, a hard numerical ceiling embedded in federal law. That cap is 66,000 visas per fiscal year, and Congress split that number into two equal halves. 33,000 visas for workers with start dates in the first half of the fiscal year, which runs October through March, and 33,000 visas for workers with start dates in the second half, which runs April through September. That second half, the one that covers the core of the American summer season, is the one that USCIS has now officially announced is full. The cap has been reached. The window is closed. But here's the catch that most people are missing, and this distinction matters enormously. When USCIS says the cap has been reached, they do not just mean they have stopped approving petitions. They mean that any I-129 petition, that is the petition for a non-immigrant worker, the form employers must file to sponsor an H-2B worker. Any I-129 received after the cap was hit will be rejected and physically returned to the employer. Not held, not waitlisted, returned, along with the filing fees. USCIS will not process them. They will not be reviewed for merit. The employer gets their paperwork back and is told, in effect, to wait until the next cycle. This is not a delay. This is a full stop. Now let's talk about the direct and indirect impact of this announcement, because the ripple effects go beyond the obvious. The direct impact is straightforward. Employers who needed H-2B workers for summer 2026 operations and did not file in time are now locked out of the program for this cycle. For a landscaping company that runs 90% of its revenue between May and September, losing access to its seasonal workforce is not an inconvenience. It is an existential threat to the business. For a beach resort that had approved workers waiting on visas to arrive for Memorial Day weekend, the announcement triggers a cascade of operational failures that cannot be quickly solved by hiring locally. Because if local workers were available and willing to do the work at the wages offered, the employer would not have needed the H-2B program in the first place. That is literally the legal requirement built into the program. Employers must demonstrate they tried to hire American workers first. The indirect impact is subtler but equally serious. Workers abroad who had already received job offers, signed contracts, made travel arrangements, and in some cases quit other jobs, or made financial commitments in anticipation of coming to the United States, are now in limbo. Their approved petitions, if filed before the cap was reached, remain valid. But workers whose employers filed after the cutoff are facing a collapse of plans that were months in the making. This is where it gets critical for anyone who is an employer in an H-2B dependent industry. The question everyone is asking right now is there any way forward? And the honest answer is possibly. But it depends on factors outside your control, and you need to understand both the realistic options and the significant uncertainties surrounding each one. Let me walk you through what actually exists as a pathway from here. The first thing every affected employer needs to understand is the concept of supplemental H-2B visas. Congress set the statutory cap at 66,000, but Congress also gave the Department of Homeland Security the authority to release additional visas above that cap in years when the administration determines that the needs of American businesses justify it. These supplemental allocations have been issued in several recent fiscal years, sometimes in tranches of tens of thousands of additional visas. However, and this is critical, supplemental visas are not guaranteed. They are discretionary. They require DHS to formally announce them, publish a notice in the Federal Register, and go through an allocation process. In some years, supplemental visas have been released relatively quickly after the cap was reached. In other years, they have been delayed, reduced, or structured with conditions that not all employers can meet. As of right now, there has been no announcement of supplemental H-2B visas for the second half of FY 2026. Employers hoping for a supplemental release are, at this moment, waiting and watching. The second pathway involves what the program calls cap-exempt workers. Not every H-2B worker counts against the annual cap. There are specific categories of workers who are legally excluded from the numerical limit. Fish row processors, fish row technicians, and supervisors of those workers are cap-exempt under a specific statutory provision. Workers performing labor in the Commonwealth of the Northern Mariana Islands and Guam are also treated differently under a separate program. Returning workers, those who held H-2B status in one of the three most recent fiscal years, have in some years been exempted from the cap under special rules, though that exemption is not always in place and depends on whether DHS has formally announced it for the current cycle. Employers who have any of these categories of workers in their workforce pipeline should consult immediately with an immigration attorney to determine whether those workers might qualify for cap-exempt processing. But here is what most employers are not considering. And this is where the emotional reality of this situation hits hardest. Let me tell you about a situation that is unfolding right now in a coastal town in South Carolina. The business owner's name is fictitious, but the circumstances are drawn directly from the reality facing H-2B dependent employers across the country. Marcus runs a mid-size hospitality group, 2 hotels and a restaurant near the beach. His peak season runs from late April through Labor Day weekend. Last year, he successfully brought in 14 H-2B workers, housekeepers, kitchen staff, and maintenance workers. It was not easy. He went through the full Department of Labor certification process, ran the required job advertisements, documented that no qualified American workers applied for the positions at the offered wage, and filed his I-129 petitions on time. His workers arrived, the season ran smoothly, and he planned to bring most of them back for 2026. This year, Marcus's attorney filed his petitions, but they were received by USCIS just after the cutoff date for the second half of FY 2026 cap. The petitions came back. The workers, people who had already told their families back home they were returning to the United States for the season, people who had budgeted their year around this income, are now waiting on a supplemental visa announcement that may or may not come in time for the summer season. Marcus is now trying to figure out how to staff his hotels for July and August with a workforce gap he did not see coming in a labor market where seasonal hospitality positions in his area have gone consistently unfilled by domestic applicants for 3 years running. Marcus's situation is not a failure of effort or planning. It is what happens when a congressionally mandated cap runs out before the demand does. And it is happening to businesses in dozens of states right now. So, what do you do if you are Marcus? What do you do if you are an employer who just got your I-129 returned, or a worker who is now uncertain whether you're coming to the United States this summer? Here is the 3-step action plan you need to execute right now. Step 1, document everything and preserve your place in line for a supplemental release. If USCIS returns your petition, do not discard it. Keep every piece of that filing. The I-129, the Department of Labor temporary labor certification, your recruitment documentation, your job offer letters, every receipt and correspondence. If DHS announces supplemental H-2B visas, there will be a filing window, and employers who have their documentation complete and ready will be able to move immediately. The employers who scramble to reconstruct their filing package will lose days they cannot afford to lose. Be ready to file the moment a supplemental window opens. Step 2. Contact your congressional representatives today. I want to be direct about this, Rokai. Contacting Congress is not performative. It is strategically useful in exactly this kind of situation. Members of Congress who represent districts with significant tourism, hospitality, landscaping, or seafood industries have a direct political interest in H-2B supplemental visa releases. Their offices hear from constituents about this issue, and those constituent contacts directly inform the pressure those members put on DHS to act quickly on supplemental allocations. If you are an affected employer, a call or written message to your senator's or representative's office is a legitimate and potentially impactful action right now. Organizations like the National Federation of Independent Business and industry-specific trade associations are already mobilizing. Connecting with them amplifies your voice further. Step 3. Protect yourself from fraud because this environment is dangerous. Every time there is a visa cap announcement, every time there is urgency and scarcity and desperation in an immigration category, predatory actors appear. They will approach employers and workers with promises of special access to H-2B numbers, guaranteed approvals, workarounds, and shortcuts. None of it is real. There is no special list. There is no back channel to additional H-2B numbers that an unlicensed consultant has access to. Anyone charging large fees to guarantee H-2B approval or to secure cap-exempt status that has not been officially announced is committing fraud. Verify any immigration professional you work with through the USCIS website or your state bar association. Do not pay anyone who cannot document their credentials and explain their process in plain language. Now let's zoom out, and because understanding what happens next in the policy process is important for managing your expectations and your planning horizon. The supplemental H-2B visa program, when it has been activated in past years, has typically been announced sometime in late spring or early summer. But the current administration's posture toward immigration broadly, including temporary worker programs, introduces genuine uncertainty about whether a supplemental release will come, how large it will be, and what conditions might be attached. In past cycles, DHS has sometimes limited supplemental visas to returning workers only, or to specific industries, or to workers from designated countries. Any supplemental announcement in 2026 will need to be read carefully because the details will determine who actually benefits. Congress could also act legislatively to raise or eliminate the H-2B cap entirely, something that has been proposed by bipartisan coalitions of lawmakers from states heavily dependent on seasonal industries. That legislative movement exists. It has not succeeded in passing a standalone cap increase into law, but the political pressure is real and growing with each year that the cap runs out faster and earlier than the year before. The workers and employers caught in this gap are not statistics in a policy debate. They are the people who make the American service economy function during its highest demand periods. They are small business owners who built their model on a legal program that the government created and encouraged, now discovering that the program has a ceiling that arrives before the season does. They deserve clarity. They deserve honesty. And they deserve to know exactly where things stand and what their options are, even when the options are limited and the timeline is uncertain. That is what we are here for. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration Path USA right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential.